Happy New Year, everyone. Welcome to the January 2022, New Year, TSCA 3030. What we have traditionally done in January is do a kind of a recap of the prior year. But quite frankly, with the new Biden administration, this has been such a difficult year for the chemical industry, we decided not to revisit it. What we're going to talk about today is one example of what the Biden EPA is now doing. And we've mentioned this before. They're moving away from, looking at chemicals in terms of use by use or conditions of use by use, and now looking at the chemical as a whole. And that's been referred to as a binary approach, binary meaning 1-0. Either it's poses unreasonable risk or it doesn't. They've issued a revised risk assessment for the flame retardant HBCD, and that gives us some clue as to how this is all going to play out. Next slide, please. So I'm Herbert Stryker. I give a lot of these. Next slide, please. And I'm joined today by two of my partners. First, David Fisher, who you all now should know was the Deputy Assistant Administrator in the Office of Chemical Pollution and Prevention and Safety. And David is uniquely positioned to comment on the Biden administration's unraveling of all the fine work that was done during the Trump administration. Next slide, please. Next slide. Yes, I'm also joined by my partner, Eric Gotting, who's done a few of these. As you know, he's an environmental litigator at Keller and Heckman, and he's going to comment on whether what EPA has been doing is lawful, and if not, what industry to do about it. Next slide, please. So, what's been going on? Well, I think you probably know, in particular, if you've been listening to our TSCA 3030s, is that the Biden EPA is revisiting all of the Trump-era risk evaluations. These are for the first 10 chemicals. They're revisiting all of them pretty much. And what they plan to do is they plan to apply their policy changes to the first 10 TSCA risk evaluations, primarily to no longer rely on the assumed use of personal protection equipment. Which, by the way, as I find rather puzzling, because as I read the term conditions of use, a risk evaluation should take into account, what is known or reasonably anticipated use of a chemical. And that I think would also include whether PPE is being applied. And so I really don't understand the idea, and maybe David can comment on this when he speaks, that, if OSHA mandates the use of respirators for a certain chemical, or the use of gloves or other PPE, why EPA should ignore that when they do risk evaluations. But maybe David can comment on that. And most importantly, what most of this webinar is about is that EPA is now used to move to looking at chemicals in terms of the whole chemical. So they look at all the uses of the chemical, all of the defined uses of the chemical, and then make a decision as to whether the chemical as a whole poses unreasonable risk or not. They're no longer looking at the uses one by one, as was done under the Trump administration. Part of this revisiting, of the first 10, because I think they would prefer, because of resources and time, to basically move forward with these new policy changes going forward to new chemicals, to the new chemicals that are evaluating, existing chemicals, the new existing chemicals are evaluating, rather than revisit the first 10. However, there have been a number of NGO lawsuits challenging what the Trump administration did in the first 10, and revisiting these evaluations as a way that they're responding to these NGO lawsuits. Now, the first one they're looking at is, as I mentioned, the flame retardant HBCD. Next slide, please. Now, recall, if you had any interest in HBCD, or if you were thinking about it or read the press reports, that the Trump era risk assessment concluded that there were 6 conditions of use that presented an unreasonable risk, and 6 did not. So the 12 uses overall that were defined in the scoping document, 6 pose the unreasonable risk, 6 are not. So EPA now concludes that the same 6 conditions of use that were found to be problematic now, quote, drive the unreasonable risk determination of HBCD as a whole. So EPA has now determined that HBCD itself poses unreasonable risk, and these 6 problem conditions of use drive that unreasonable risk determination for the chemical as a whole. And they didn't do very much in their revisiting of the risk assessment, although the fact that they deleted the assumption that PPE would be used caused at least a few of the uses, which were originally only of concern for environmental risk, are now of concern for human health concerns as well. Now, as I mentioned, in the Trump era evaluations, 6 conditions of use concluded that they did not present unreasonable risk. EPA issued orders to that effect that had some very significant implications for preemption, and I think David and Erica can talk about that. But what EPA has decided to do is to rescind those orders. So there will be no unreasonable, no orders or no uses where it is determined that there is no unreasonable risk. Next slide, please. Now, EPA says actually something rather interesting in their draft revised HBCD risk evaluation. And I think, we don't have that many slides today, so I think we're going to have some time for a dialogue between the 3 of us. They say that they're not limited to only regulating those activities that drive the unreasonable risk decision. And they could select risk management options that address manufacture, processing, and distribution of commerce, use, or disposal in order to address the unreasonable risk, even if those activities relating to manufacture, processing, et cetera, do not drive the unreasonable risk determination. So we're going to want to discuss what they really mean about that. I think that could have very, very broad implications in the future. And we'll spend a fair amount of time in the next half hour talking about what this possibly means. I'm going to turn this over to my colleague, David. Next slide.
All right, thank you, Herb. And good afternoon, everyone, and thank you all for joining us. Happy New Year. Let me continue the discussion that Herb kicked off by saying that if you had read the FR notice in the revised Chapter 5 of the HBCD risk evaluation, you might think that the whole chemical approach, at least up to this point, is just confined to HBCD, but that's clearly not likely the case, right? Recall that EPA announced at the end of June last year that it intends to withdraw the previously issued orders for those conditions of use for which no unreasonable risk was found for all the first-hand risk evaluations. Herb mentioned that a few moments ago. And that pronouncement that came out at the end of June, that's actually cited in both the FR notice for the HBCD risk evaluation and in the revised Chapter 5. So there's already sort of a disconnect between that pronouncement and then what's stated in the FR and the HBCD Chapter 5 evaluation portion. So it's important to keep in mind, as Herb mentioned, HBCD is the first at bat. There will be many, many more, not just the initial 10. So in looking at the impacts of this new approach, I think it's important to note that it will not only impact risk evaluations directly, of course, but it will impact at least 2 other TSCA provisions, one of which is on this slide. So recall that TSCA and then the risk evaluation rule itself provides provisions for manufacturers to request risk evaluations. Some of you on the call today may have been engaged in some of those MOREs that have been submitted to date, and there are several, right? And the rule itself, the risk evaluation rule in section 702.37 states that EPA will conduct these assessments and make proposed determinations based on the same considerations applied in the same manner as it would for a risk evaluation for a high priority substance. So that basically means that if EPA is switching to a whole chemical approach with regard to the risk evaluations that they initiate, that logically and based on this rule legally, that would mean that manufacturer requested risk evaluations will also be subject to the whole chemical risk determination approach. Next slide. So if EPA will no longer determine that certain conditions of use in an MRE, manufacturer requested risk evaluation, do not present an unreasonable risk, well, one would think that that would clearly disincentivize the submission of future MREs. What remains to be seen is how will EPA deal with the ones that have already been submitted? So that's a question mark out there. But for those that haven't been initiated, one wonders, well, there will be any more other than the ones that are already being processed by the agency. Because if your hope in filing one of those manufacturing request risk evaluations is that you are hoping and have the data to support a determination by the agency that your condition of use that is, part and parcel of your operations of your company will receive a no unreasonable risk determination, I think it's highly unlikely that that will ever happen again under a whole chemical approach. So you might say, well, wait a minute now, if they're not going to do it by conditions of use, is there still a chance that EPA could deem an entire chemical as not presenting unreasonable risk? I think that's highly unlikely, because for EPA to do that, that's basically saying it's a low priority substance. And I just find it highly unlikely that EPA would agree to evaluate a manufacturer requested substance only to discover that substance was in fact really a low priority substance, and frankly should never have really been evaluated by the agency. So that's why I'm saying that the future of no unreasonable risk determinations, especially for those who seek them by filing a manufacturer requested risk evaluation, I think those days are over. If this whole chemical approach risk determination remains intact and continues to be embraced by the agency. The next slide. So there's another important aspect that I wanted to bring to your attention as well, and that's about preemption. I'm sure folks have been wondering, what does this whole chemical risk determination approach mean for preemption? Okay, so you're all probably familiar or know that Section 18 has a long-winded, very complicated, not easy to decipher preemption provision. It's probably the longest in all of federal law, frankly, that as far as I know. So it's not easy to decipher, but let me just try and distill it down to a couple of slides here that I think are really the key to keep in mind. So generally, and there are some exemptions and waivers, but generally under Section 18C3, federal preemption applies to, quote, the hazards, exposures, risks, and uses or conditions of use included in EPA's order regarding no unreasonable risk determinations, or a TSCA Section 6A risk management rules to address unreasonable risk. So those sort of the two buckets. Orders are needed for no unreasonable risk determinations, and management rules are needed to address unreasonable risks. Okay, next slide. But if EPA no longer issues orders for certain conditions of use that do not present unreasonable risk, preemption can only be triggered then through issuance of a risk management rule. Okay, so then if the notion that you don't get preemption anymore for no unreasonable risk determinations because no more orders will be issued, is there any hope that a risk management rule might reference or might include those conditions of use for which EPA, that don't in fact present unreasonable risk? EPA would not have made that determination but it's pretty easy to go back to chapter 4 of each risk evaluation, especially if, and make a determination yourself, especially if the MOE, for example, is orders of magnitude higher than the benchmark MOE. And that's certainly the case for HBCD. If you look at the no unreasonable risk determinations, some of those demonstrate MOEs that are literally over 1,000 times higher than, or nearly, if I recall correctly, than the benchmark MOE. So then what about the risk management rule? Does that provide any sort of hope that you could cobble together an argument that the risk management rule could still be used or referenced as a determination, even implicitly, that your condition of use does not present unreasonable risk? Well, a couple of responses to that. If you look at chapter 5 for HBCD, you will see that it is entirely devoid of any discussion of any of the conditions of use that don't drive the unreasonable risk determination for the whole chemical. It's just gone. Okay. The statute makes clear that no unreasonable risk determinations, that no unreasonable risk determinations can be issued only by an order, not by a rule. So not only do you not have anything actually in the risk evaluation of chapter 5 in particular that you can hang your hat on with regard to those conditions of use that you're quite certain do not present unreasonable risk, but it's highly unlikely that you can use the rule even sort of in implicit in an implicit manner to argue that you can still seek preemption for your conditions of use that don't present unreasonable risk. So therefore, at the end of the day, if the whole chemical risk determination approach continues to move the way this administration would like it to move, the orders are gone. Preemption based on those orders is also gone. And a risk management rule will only be for risk management of unreasonable risk as it applies to the whole chemical. And as Herb mentioned in one of his slides, there's a great deal of discretion that the EPA is seeking to manage the chemical as it deems fit to remove that unreasonable risk determination for that chemical through the risk management rule itself. So a lot more to understand about this approach, and we'll have to sort of wait to see what happens. But let me now turn to my colleague Eric, who has some fascinating slides and discussion on the litigation side of this whole issue. So thank you. And Eric, next slide, please.
Well, thanks for joining us today. So another key question that is raised by the HBCD proposed risk evaluation is whether EPA can just simply give a new interpretation to an existing framework rule without going through a whole new notice and comment rulemaking procedure. So in other words, can it go from what the Trumpy EPA did, which was making unreasonable risk findings based on each condition of use, to now what the Biden EPA wants to do in applying a whole chemical approach? So as some of you may recall from a prior 3030, we explained that TSCA itself requires risk evaluation processes to be established through notice and comment rulemaking. And you may also recall that the Administrative Procedure Act requires that anytime a regulation is essentially changed, the agency has to go through another round of notice and comment rulemaking. So why does the Biden EPA think it can skip the notice and comment step? Well, if you read through the preamble of the HBCD proposed evaluation, you will see a lot of talk about ambiguity. The Biden EPA argues that both TSCA itself and the current framework rule that governs unreasonable risk findings are ambiguous on this point and whether a use by use or whole chemical approach is allowed. And there is a reason for all of this. In administrative law, courts will often defer to an agency's interpretation of its own existing regulation without requiring new notice and comment. So in the past, we often called this Auer deference, A-U-E-R, and that's named after a Supreme Court case, Auer v. Robbins. And in that case, the Supreme Court said courts should defer to an interpretation unless the new interpretation is, quote unquote, plainly erroneous or inconsistent with the regulation. So that sounds pretty good, pretty favorable for EPA, and it is. Courts have often applied this rule in a very deferential manner, believing that the agency is going to know more than the court would about what the regulation actually should mean because the agency wrote it. And deference should be at its highest when dealing with technical and scientific issues that are within an agency's expertise. Next slide. But in 2019, the Supreme Court decided to revisit the Auer deference doctrine in a case called Kaiser v. Wilkie. And to make a long story short, while the court in a 5-4 decision upheld the doctrine, it decided to make it more difficult for courts to apply and for agencies to successfully invoke. So essentially, the Supreme Court now requires a court to go through a deliberate multi-step process before it can defer to an agency's new interpretation and without requiring notice and comment. And the Supreme Court made clear that Auer deference should be more exacting and more difficult to successfully use than we had seen in pre-Kaiser decisions. So what are the steps? Well, first and foremost, the existing regulation has to be genuinely ambiguous, and this you'll see is very important. And so the court must use all of the traditional tools of kind of statutory and regulatory interpretation to make this decision, such as looking at the regulation's text, its structure, its history, and purpose. And if it is not ambiguous, then the court must enforce the plain meaning of the regulation, and no deference is given. So if the agency wants to apply a new interpretation, it has to initiate new notice and comment proceedings. Second, if the regulation appears to be ambiguous, then the court asks if the interpretation is reasonable. And then third, the court must ask a few more questions, like if an authoritative figure within the agency has set forth a new interpretation, not just a lower level staffer. Was the agency's particular expertise used in formulating the new interpretation? And does it appear that the agency gave the issue fair and considered judgment? So can EPA rely on Kaiser deference to adopt the whole chemical approach without going through notice and comment? Next slide. Well, let's go back to the specific language of the framework rule. As part of the risk evaluation, it says, EPA will determine whether the chemical substance presents an unreasonable risk of injury to health or the environment under each condition of use within the scope of the risk evaluation, either in a single decision document or in multiple decision documents. Next slide. So when one reads EPA's preamble to the HBCD proposed risk evaluation, one gets the impression that EPA struggles to meet the first factor of Kaiser. In other words, showing that the regulation as it stands now is genuinely ambiguous. So first, EPA seems to ignore the plain language of the regulation itself. In the preamble, the Biden EPA says the regulation references a risk determination for a chemical substance under all conditions of use, rather than a separate risk determination for each condition of use. But that's not what the plain language of the provision states. As codified, the regulation clearly discusses doing single individual unreasonable risk determinations, and that they can issue multiple determinations in multiple documents. And that's very important. So it's very difficult to read the plain language as meaning anything other than requiring a use-by-use determination. One has to really strain to read a whole chemical approach into this language. Second, in an attempt to create some ambiguity, the Biden EPA says that 70247 is based on only a single passage in the final framework rule, the preamble to it, thereby implying that if the Trump EPA had really meant to institute an approach based on use-by-use determinations, it would have spoken at more length. But there are several problems with this. To begin, the alleged single passage makes clear that the Trump EPA was in fact doing just that. It says that EPA will be making individual risk determination. So that certainly doesn't help the Biden EPA. Moreover, contrary to the Biden EPA's claims, this is not the only statement in the preamble that was made along these same lines. Earlier in the preamble, the Trump EPA says that it may conduct risk evaluations in stages and, where possible, issue early risk determinations for particular conditions of use. In contrast, there would be no reason for multiple decision documents, as stated in 702.47, if a single whole chemical determination is applied, because then you would just have one document. And later in the preamble, and this is even more important, the Trump EPA clarifies the use-by-use approach at least 2 or 3 more times, including that a determination that a particular condition of use does not present an unreasonable risk, or where that happens, it will be a final EPA action, that order, and it will be subject to a separate order. So these statements taken individually or together clearly indicate that the Trump EPA intended for 702.47 to establish an approach based on use-by-use determination. Third, the Biden EPA tries to muddle things further by noting that other regulatory provisions from the final framework rule seem to focus on the chemical substance itself and never mention individual risk determinations. For example, it cites the 702.31 as saying that the purpose of these regulations is to determine whether a chemical substance itself presents an unreasonable risk, and it doesn't reference any individual risk determinations. EPA also cites the 702.41a as using similar broad language, although it ignores provisions later in that section that specifically talk about making individual risk determinations. But EPA does not mention other provisions that clearly talk about making use-by-use determinations, like 702.49d, which talks about making a no unreasonable risk determination based on 1 or more conditions of use. In any event, a court will likely not read those regulations in isolation, but instead will read them in the context of the regulations as a whole, including any provisions that specifically provide for use-by-use determination, as well as the various statements in the preamble to the framework rule that we just discussed. So finally, EPA cites another statement in the preamble to the final framework rule, where the Trump EPA says it has discretion to determine whether a chemical substance, not just individual uses or activities, presents an unreasonable risk, thus implying that the decision should be based on the substance as a whole and not separate conditions of use. But this statement was made in the context of a discussion regarding how EPA will go about initially identifying the conditions of use it would evaluate, not how it would ultimately make an unreasonable risk determination. And again, when read in the context of the entire preamble, the Trump EPA clearly said it was going to make risk determinations and issue orders on those conditions of use that do not present an unreasonable risk. Now, also recall that the Kaiser decision also requires courts to look at the purpose of the regulation to determine whether it was genuinely ambiguous. So in this case, when it was talking about 702.47, the Trump EPA said a number of times that the goal is to focus on conditions of use that raise the greatest potential risk, and to ensure that EPA meets the risk management deadlines for those chemicals. So this is entirely consistent with an approach that resolves those conditions of use that don't present an unreasonable risk, so that EPA can focus its resources on only those uses of concern. In other words, the goals underlying the regulation do not lend themselves to a finding of ambiguity. Now, also recall that the Kaiser decision says if the regulation is ambiguous, then that interpretation must be reasonable. But we have already identified other risk evaluation regulations that wouldn't seem to make sense if a whole chemical approach was required, such as 702.49d. So certainly it would not be reasonable to read 702.47 as allowing a whole chemical approach if it renders other provisions meaningless. And I wanted to bring up one last point. The Biden EPA cites in the preamble for support to the Ninth Circuit's decision in the Safer Chemicals Healthy Families case back in 2019. The NGOs argue in that case that a use-by-use approach was not permitted under TSCA, and the court, although the court did not make a decision on this point, it eventually held that the issue wasn't ripe. It did, in making the ripeness point, the court said that 702.47 is ambiguous. The problem for the Biden EPA with citing to this decision is that the Ninth Circuit did not apply the Kaiser factors. In fact, it looks like the court applied the much more deferential approach seen in our cases and rejected by the Supreme Court in Kaiser. For example, the court did not consider the Trump EPA's explanatory statements in the preamble to the framework rule. And it also didn't focus on the purpose underlying the use-by-use approach as articulated by the Trump EPA. Instead, the court just gave a very deferential, hypothetical kind of interpretations of 702.47 and other provisions which may not fly in our post-Kaiser world. So it isn't clear that the Ninth Circuit decision is even persuasive on this point. Now, all of this does not mean EPA is guaranteed to lose a lawsuit claiming that notice and comment rulemaking is required to change the interpretation of 702.47. It may be that further analysis reveals some genuine ambiguity, and I certainly haven't exhausted today all the avenues of inquiry. For example, EPA points out that TSCA itself appears ambiguous and that it seems to refer to conditions of use collectively, not individually, when discussing unreasonable risk determinations. But whether that point allows for Kaiser deference or would only come into play during a subsequent notice and comment proceeding remains to be seen. But in any event, I think it's safe to say that we could see litigation on this issue in the near future. And so I think that's it. What's the next slide?
Thanks, Eric. I'm gonna, if people don't mind, since we don't have a reach 30-30 following this, I'm gonna extend this a little bit because it is January and you know what the hell. So I want to pick up on a couple of things. The first point I want to pick up was one that I made, maybe get David's views. So this business about, you know, deleting the concept that these chemicals are being handled appropriately at the facilities where, you know, the workers are being protected with gloves and respirators, et cetera, as they're required to under OSHA rules. And whether that makes any sense. Now, the definition of conditions of use says it means the circumstances as determined by EPA under which a chemical is intended, known, or reasonably foreseen to be manufactured, processed, distributed in commerce, used, or disposed of. And it seems to me that would include, you know, how the chemicals are handled at the manufacturing and processing facilities. And if these chemicals are handled at these facilities and the workers are wearing PPE, then how can EPA ignore that when they do their risk evaluation? David, any thoughts on that?
Yeah, I know it's a good question, Herb. Thanks for bringing it up again. So we did have discussions about that very issue at EPA while I was at EPA, because it was brought up in not only public comment, but I believe maybe even the SAC reports might have referenced it too. But at any rate, it was clearly on our minds, and we thought we could build out some of the discussion in each of the risk evaluations regarding uncertainty, and which is obviously a factor in the eventual calculation of an unreasonable risk determination. So if you looked at each of the risk evaluations that were finalized, there is discussion over this very issue.
Right.
We thought it made more sense to assume folks are following the law, because if you extend that out, should we have assumed that folks are not following Clean Water Act provisions and just unleashing all sorts of chemicals untreated into water bodies? What about the Clean Air Act? Should we assume folks are not following their permits? I mean, at some point you have to assume that conditions of use, as you point out, Herb, means the way it's supposed to be used, the way it's supposed to be treated, for example, or emitted, or what have you. So
absolutely. So you know, I mean, it doesn't say use; it says conditions of use. So where's that term come from? Well, I suspect. Well, first of all, I believe that actually term came from one of the trade associations' drafts of the TSCA amendments, and quite frankly, conditions of use actually is a concept in REACH. That's that phrase. That phrase only shows up one place elsewhere in the universe before the Lautenberg Act, and that's the REACH regulation. Conditions of use means under REACH, you know, that you look at, you know, all the risk management measures that have been put in place, you know, for this chemical, and whether it, you know, is safe after you've implemented these risk management measures. And that's conditions of use. And so I really don't understand, you know, what the Biden administration is doing here. If you assume that people are not using PPE, if you assume they're not following their permits, if you assume, you know, unprotected, the workers are totally unprotected, then any use of these chemicals, you know, going to be unsafe. So I don't even understand that. So that's the problem. Secondly, let's talk about the manufacturing request for risk assessments, which I think risk evaluations. So I think you made a very good argument there, David. Let me ask you this. What's the point of having those if EPA has to separately research and do evaluations on uses that are not proposed for evaluation by the manufacturer? I thought the whole point here was that that a manufacturer would ask for risk evaluation on their use. They'd have no interest in doing asking EPA to do a risk evaluation on somebody else's use, but their use. And the EPA would evaluate it, and that would be kind of an easy way to deal with some uses of some chemicals and also get some funds, because it's very, very important. If you look at the Senate report, they assume that a large part of the TSCA program will be funded from the fees collected from the manufacturer's requested risk evaluations. So I mean, where is EPA going to get the resources to look at the chemicals as a whole when the manufacturers are only providing information on their particular use? And does that make any sense? Does that whole process make any sense if you go to a whole chemical approach?
Yeah, no, I think it makes even less sense now, Herb, as you indicate, with a whole chemical approach. I would be shocked if anyone were to file one. And you're right, that's going to have an impact on the level of revenue stream for the agency. So does that mean they're going to have to up the fees for other activities under TSCA?
I think they have to. I mean, they're already complaining that they have limited resources, not enough funding, and I think they're just creating busy work for themselves, quite frankly, for no particularly good reason. Let me ask you this. I mean, I guess let's go to the. By the way, EPA has provided a comment period on this proposal for Valentine's Day, February 14th, and we're going to be reaching out to some of you on the phone to see if you're interested in preparing comments. You may not care about this chemical, but quite frankly, you should care about the concept, because at some point in time, one of the chemicals that you care about are going to be at bat. And so we're going to be reaching out to a number of you. And if you want to be preemptive and email me at strikercagelaw.com, say you want to be part of that discussion, because February 14th is not very much time. It's about a month to organize something. But I think it's very, very important that industry weighs in heavily against what EPA is planning to do here. First of all, it's sort of just changing the rules in midstream without undertaking notice and comment seems to me to be unseemly. Quite honestly, there's no question what the Trump administration intended. They revised what the Obama administration had proposed in January of 2016. There's no question that the Trump administration moved to a use-by-use approach. I don't see how you could possibly have an interpretation otherwise. And so, what the Biden administration is trying to do is they're trying to bypass all that and just sort of march forward, and they're hoping that industry won't complain. But I think it's time for industry to say that we are not going to take it anymore. We are tired of this and not going to take it anymore. And so we'll be reaching out to several of you. Anyway, I thought that Eric's analysis was very persuasive. And I think, David, you hit it on the nose here in terms of what the implications of this are. Let me sort of ask you something about an aggregate risk assessment. I mean, what is the point of doing the whole chemical approach if you don't actually plan to aggregate the risk? Is there any purpose to this?
Yeah, I guess I view it as sort of what's stated in the actual HBCD documents that were released for public comment. And that is, if you do a whole chemical approach, then you have tremendous discretion in terms of how you're going to manage that unreasonable risk, because you're looking at the whole chemical. So you can go upstream, downstream, doesn't really matter, as long as you have identified enough conditions of use that would allow you to deem the whole chemical to present unreasonable risk. What's unclear to me, Herb, is even though the EPA has said that a majority of the conditions of use for this HBCD presented unreasonable risk. That's not true. It's as you mentioned earlier in your slides, it's half, 6 no unreasonable risk, 6 unreasonable risk. But what if you only had 1 or 2 or 3 conditions of use out of maybe 15? How do you go about how do you initiate authority to manage those risks if you don't deem the entire chemical as posing unreasonable as posing unreasonable risk?
Right.
I mean, is EPA going to split it and sometimes do a whole chemical approach and sometimes not? That seems even more arbitrary than their current.
I mean, again, I'm not really sure what they're trying to get at here by looking at the whole chemical. I mean, other than eliminate the no unreasonable risk orders, I'm not really sure what they're trying to accomplish. I mean, and I agree with you. So, for example, if only one risk is a concern, only one use is a concern, do you ban the chemical? That makes no sense. If half of the uses are concerned, do you ban the chemical? Well, that doesn't make any sense. I mean, ultimately, the risk management should focus on the uses that are a problem and fix those. So I really don't understand what it is that they're trying to accomplish here. It's very, very difficult to understand what they're trying to accomplish. I think we'll only find out, as they move forward with these risk management rules. But what is it the environmental groups who've been fighting this, use by use approach that the Trump administration adopted? What are the environmental groups trying to accomplish here? Do you know what they're trying to accomplish in these litigation cases? What's their goal? Well, why would they care? If it's true, as Eric said, or maybe as you said, that the MOEs for these uses that were determined to be not a problem are orders of magnitude, higher than would be of concern, why do they sue? What are they trying to accomplish? What are they trying to accomplish? Why spend the resources suing on uses of these chemicals nobody cares about? Any thoughts?
I don't know if Eric is still on.
Yeah.
Yeah, I mean, I think part of it, and I guess it depends on whether the chemical has kind of exited the market. But if you have a whole chemical approach that just says unreasonable risk, you're putting market pressure on that chemical, and it's going to be gone before you even ever get to preemption. And so
I think that's right. I think the states, by the way, they're not going to parse through the uses. They're just going to ban chemicals. If they're not precluded from doing that, the preemption provision, then they can just go forward. And I think this is all a prelude to that. It's either the prelude to convincing EPA to do, instead of end of pipe regulation, to have them do bans. And if the EPA is not willing to do bans, and have the states do it. I think that's what's going on here, quite frankly. Anyway, we still have a lot of people. We've lost a lot of people. Everybody have a great January. We'll see you in February.
Yeah.
Thanks,
everybody.
With more good news coming out of the Biden administration. Take care, everybody. Bye-bye.